So I read your motion, and I read your response, Ms. Van Dyken. Anything you want to add to that, Ms. Wagoner, before I may have some questions, or Ms. Van Dyken may have something to add to her response? I'm giving the floor to you.
Thank you. I would just simply respond to Ms. Van Dyken's response. I do believe there is a change in circumstance, and I don't think her response denies it because Mr. Van Dyke is not exercising any overnights with his son. And I do get that the child is 18 and that is hard to enforce, but that doesn't change the fact that my client is providing for his housing, his living expenses, his food, the gas to keep the house warm, the electric, the water to drink and shower and bathe and do laundry and all of those things. And I think the lack of overnights is a solid change in circumstance to warrant a child support review. In addition, my client.
Oh, I'm sorry, go ahead.
No, I was just going to say, in addition, my client has had the now adult child for over half of the year, and hence her request to claim the child as a tax exemption for the 2024 tax year.
Is Mr. Van Dyke financially contributing to the situation, i.e., is he current on his child support? I think Ms. Van Dyken said that he takes care of all the parochial school tuition, takes care of the vehicle expenses. So he's not, the fact, I agree with you that there may or may not be a change of circumstance, but is it true that he's doing those?
I'm not denying that he's doing those. My client is also paying for insurance and those types of expenses as well. So I would assume he's current on child support. I don't know that. I haven't heard any differently, but they're both paying for the added expenses as it relates to this child, as well as my client is paying for the primary necessities.
Thank you. Ms. Van Dyken.
I'll start with the tax exemption. That's a property issue. That property issue was settled, and that's not up for discussion. You don't get to just change it. With regard to the insurance that Ms. Wagoner says that Ms. Van Dyke pays, that must be insurance for her own home or her own health insurance. My client pays the car insurance for the car that he purchased for the child, and the school tuition for both children, and the extracurricular activities. Again, I think I think the court refers to these children as the 800-pound gorilla, but this is an 18-year-old adult gorilla. So where he chooses and takes himself in the car that my client provides for him is that. I don't believe that, A, the tax exemption is an issue that should remain split between the parties. And I don't believe, and it's my understanding that he'll be graduating in May. So we're talking about January, February, March, April, May, 5 months. And he is current on his support, Your Honor.
So it's interesting. This is kind of a one of those somewhat gray areas where it's more than an 800-pound gorilla. It's a 900-pound gorilla, because I can't tell him what to do even if I wanted to. I can't tell him go spend overnights at your dad's, because nor could I hold Miss Van Dyke in contempt of any kind for him not doing so, because he's an adult. Obviously, just as he apparently chooses not to spend any overnights with Mr. Van Dyke, he could tomorrow choose not to have any overnights with Miss Van Dyke. I mean, it's just how it works with these children. As far as the tax exempt, well, let me start with the child support first. Obviously, looking at the UCSO, it's clear that the child support amount was based on overnights, because it's 182.5 for both kids. And that the fact that he's not having overnights, that I agree with Ms. Wagoner, is a change of circumstance. And I think that either the parties should either try and come up with their own plan, or I can send it to the friend of the court for this finite period of time. The tax exemptions are a different story. Whether it's the child support, whether it's a property, that's always the biggest debate in food. But the tenancy exemptions are based on more than just overnight. They're based on a shared economic responsibility. Sometimes it's more, sometimes it's less. But even though he doesn't exercise overnights or have overnights, he obviously is contributing financially to the situation, paying child support, paying school tuition, vehicle expenses, just as your client is. So I'm going to grant the motion as far as proper cause or change of circumstance. I'd be happy to refer it to the friend of the court for an investigation and recommendation. It shouldn't take that long. I'm going to respectfully deny the change in the tax exemption. However, I don't believe that has been shown to be in the best interests of these children to fiddle around with that at this point. So I guess I can ask you both. You both have margin soft. You both know how to run guidelines. If you want to take a crack at it first, or do you want me to sign the order of reference today?
Can I?
I don't have a problem with Ms. Van Dyke and I exchanging income information and running the guidelines. If we can't reach an agreement within the next, before the end of the year, basically, I would say we can reach back out to your office for a referral, if she's okay with that.
That's fine.
Okay. All right, let's do that then. Let's see if we can get it together. You guys got more important things to worry about than sitting in court. You guys got a plan for a graduation coming up, and just so both of you know, if you think once they turn 18, they get cheaper, you got another thing coming. They get more expensive, quite frankly. But I wish you both the best. Have a great holiday. Ms. Wagoner, Ms. Van Dyke, thank you both very
Can I
much.
say one
Thank
thing
you.
about one? Is it
Probably not.
possible?
I don't
No.
think the attorney
Okay.
wants you to talk.
Okay, that's
You can
fine.
talk to her, she'll listen to you, but
Yeah,
a lot of times attorneys will slap me if I start listening to their
yeah, it's okay. That's okay.
client. Okay, all right. Have a great holiday. Thank
Thank
you.
you.
Thank you.
We're unfortunately we're back yet again. We've been here. The motions have been set July 5, November 22nd, and now and 12/6, and now we're here today. I get the first part of this, Mr. Palmer, because we need to seal the CPS report that's in the file. So I will grant that part of your motion. And you need to prepare an order sealing the CPS report from the court file. The Legal Assistance Center on the 5th floor can show you how to do this.
Oh,
What I'm more puzzled about is the second motion you have. It says a motion for parenting time, and I think we already shoveled that walk, didn't we?
yes, we had a conversation about that. It
Well,
was
we
a,
did more than that. We sent it to the front of the court, and they are hopefully in the middle of an investigation and recommendation. And they're going to meet with both of you to see if it can be resolved. And if it can't, then they're going to conduct a investigation and recommendation to me that the parties are free to accept or reject. And then if they reject it, if one party doesn't like it or both parties don't like it, then we got to have a whole trial on this. But I already set the wheel spinning on parenting time. What you asking me to do today?
honestly, it was a misunderstanding through, I don't know if you're familiar with Project Green, which is a grant funding project through FOC. I've been
I
in
heard
with,
something, but
okay, I've been in contact with them. It just was a misunderstanding.
have you heard from the friend of the court yet? Both of you?
I've just received a letter yesterday from them. It's been a while. My only concern was, basically want to see my daughter more, having to wait, for FOC to get involved to see her, it's kind of frustrating. I appreciate you granting me the parenting time that you did. I did spend time with my daughter last weekend. I appreciate that. But I feel like I need to be in my daughter's life more. I need to see my daughter when I want to. There's no restrictions on my parenting. Hey, I'm sorry about that, sir. There's no restriction on my parenting. All my child support is caught up. Everything, nothing. The only one who says I can't see my child is the mother, and she has no say so on that.
Well, it's not quite accurate, but
By law, Michigan is a 50-50 state to my knowledge.
no.
I do pay child support.
Oh, you do, Mr. Deans,
Yes.
but I don't want you to get into trouble. People that start quoting the law to me usually don't end up very well. Because what I try and do is, I will always over prepare motions. We are not a 50-50 state. I know there's talk of trying to get there someday. Obviously, both parents have to, if there's an order out there, both parents have to follow it. If there's not an order for it, then we have to get one. And that's what I'm in the process of trying to do. I can't do that on a Friday morning because the law says that I have to have an investigation that deals with more than just, this is what I want. I need to deal with all the best interest factors, and there's 12 of them. And I can't possibly do that on a Friday morning. That's why I sent it to the front of the court. Now, obviously, I would hope that at some point in time, you, Mr. Deans, and you, Ms. Palmer, get to a point in your lives and in the lives of your child that you can simply work it out between yourselves, but you two are not at that place right now. And I'm trying to help you with that regard. So you'll have plenty of opportunity at the front of the court to reach an agreement with Ms. Palmer. But usually, and if you go in with somewhat of a negative, it's not going to happen attitude, I hope that it does. There's going to be somebody to help you do that, and hopefully between that person and the friend and Miss Palmer and you can reach some sort of accord and get to where you want to get to. But right now, you're not at that place, and I'm taking all the things the law allows me to do to get this thing moving forward for you. So I appreciate the fact that it does take a little while. It does. I apologize for that. But this whole process is more than just coming in on a Friday. But I will grant the first part, and you can prepare an order sealing the CPS transcript, and then I can get you out of hot water on that issue. And I'll deny the parenting time because that issue right now is currently pending at the front of the court.
I do have a,
What can I do for you, Ms.
okay, so we do want parenting time. We both can agree on that, him and I. But I do have a question when it comes to, I did receive an email from the FOC, and it says something about we both have to pay $150. With the same form that you use, that you can get that waived, or is that impossible?
That's not impossible, but if both parties are working, I don't waive it.
Oh, okay, no worries. No, I can pay it. I just was asking.
Both parties are working, then I don't waive those fees. So, but make sure you comply with that stuff, because if they terminate this, we're back at square one. And they're going to meet with both of you first. That's their step one before they do any investigation, is they sit down with both of you and say, let's get busy. Let's come up with something we can all live with.
Mhm.
So I hope you succeed in that regard. So thank you both very much. Have a happy holiday, and we're adjourned. Thank you.
Thank you.
I got your motion, Mr. Hayes, Gory. Let me tell you what the problem is from my perspective. Your camera just went out. Can you hear me okay?
Yep, I can hear
Uh,
you. I'm sorry.
I didn't know if you were aware of this, but currently there's an active bench warrant for your arrest.
For
I'm assuming child support.
We just went.
I just went to FOC like a couple of days ago when I filed for the parental time, and I looked over all that. I just actually received a check in the mail from FOC, so I don't know how that's possible.
I don't know either. I checked it yesterday, because I always do check it, because I don't want people running into problems.
Uh,
So it might require that you contact the circuit court and not the friend of the court and see what that's all about, okay?
and I just went to circuit court too, 61st District Court, and I just went down there and put some money on fines.
Yeah.
And I don't like they. I don't understand. They told me I didn't have any bench warrants or any, you know what I mean? So I don't understand that.
Yeah, I don't either, but it's there sure as day, and I don't want to run into problems. So we need to get that taken care of, one way or the other.
Okay.
Okay?
Mhm.
All right, so you have filed a motion for parenting time, and the last parenting time order was the judgment of paternity dated February 14, 2022. And parenting time was really as the parties agree. Am I to understand that you and Ms. Burrell cannot come up with an agreement?
Mhm.
Is that true? Yeah.
No, we came up with an agreement. No, he's okay. We came to agreement to do every 3 days. And it's like when I contact Davon to get my son, he don't do it. He won't get him. Like he'll text me and say, "Oh, I'm taking him to Chuck E. Cheese at such and such time," and won't come get him at such and such time. Yeah.
So I'm kind of at a loss as to figure out what you want me to do, Mr. Hayes-Gory. I mean, if you two, I mean, what I can do,
I can agree on parenting time.
okay, then I can send you to mediation at the front of the court, and you guys can hammer out your own agreement. How's that?
It's
Okay.
just like I'm not really into. I just want the parent time. I don't really care to keep going through all the extra stuff. I just wanted to see my son. That's it. And I just wanted to be like to a point where someone can be like, "Oh well, I'm feeling like this today. You can't get him," or whatever. I don't want it to be like that.
I understand exactly what you're saying.
If she's able to agree to parental time, I am as well, and I just rather do it with you so it'd be on paper, so it doesn't have to be
you
any.
can't do it with me because I
Okay.
only do it. That would be through a trial, and I don't want to
Okay.
get to that point. I can get you two to get in agreement, and it doesn't cost anything.
What is in the mediation?
That's where you two sit down with a mediator, and the mediator will say, "Okay, you guys agreed. What do you want it to be?" And then they'll write
Can
it.
we have, is there,
Hang on. Ms. Burrell, you're too jumpy today. Settle back a minute. Let me get this out of my mouth first before you jump in. What I'm telling you is that what a mediator will do is they will write it up in legal form, so it's binding on both of you. And then you both sign it, and then it gets sent to me in the form of an order. Now, if both of you want to dispense with that step, go have coffee somewhere and write your own agreement up. You can do that too, but you got to send it to me so I can sign it so it will be enforceable. Right now, nothing's enforceable. If you decide you want to pick up your son or your child, and there's no paper that says it's your time to have your child, nobody can enforce it. And just like Mr. Hayes-Gory, if he tries to get parenting time and there's nothing on paper, then you can say, "No, you're not getting it today. It doesn't work for me." So you guys got to get it on paper, and I'm trying to get you the least way to do it, so you're not back here all the time worrying about this. And the best way to do this is option one is write your own agreement, both of you sign it and send it in to me, and I'll put it in the form of an order and sign it. Or two, go to mediation at the front of the court and they will write up the agreement, and then you can sign it there and they will send it to you. So what do you wish me to do, Mr. Hayes?
A mediation.
Okay. I'll order a mediation at the front of the court. There's no fee for that, and they will put it on paper for you and come up with an order. It'll cover everything from just the weekly parenting time to all the stuff, summers, holidays, that type of stuff.
Okay.
I'll help you out with that. So
Okay,
you'll from the front of the court shortly. I will prepare that order today and send it over there. Okay.
Okay.
All right. You both are all set. Have a wonderful holiday, and we're adjourned.
You as well. Thank you.
I have read your motion, Mr. Arnson. Thank you. You got a copy of that as well, Ms. Retamaker?
Yes.
And I read your response as well, Ms. Retamaker, and you got a copy of that, Mr. Arnson?
I did, yes.
All right. Anything you want to add, highlight, accentuate? I'll turn things over to you.
Yes, Your Honor. I think the answer filed to this motion was kind of interesting, but I just there's a lot of factual disputes here, and I don't really know if they go to the core of this case or not, but it's the simple fact is there was a judgment of custody that was entered back in 2021, April of 2021. The minor child, MK, now age 4, they had the old, as the parties agree, I think as agreed for plaintiff's parenting time, which when the parties agree, that's great. And when they don't agree, or one party doesn't agree with the other one, that's not always great. Fast forward, as laid out in the motion in February, Miss Cain had some issues with housing, and essentially the rotation or the parent had flipped, and Mr. Lucas became the primary parent of the minor child. The housing issues or instability continued for several months up until mid-September, sorry. So we've got a 7 to 8 month period where there was a significant change in the established custodial environment. And certainly we would argue that 7 to 8 months is an appreciable period of time. And I think that would amount to and I think case law suggests that amounts to a change of circumstance. The parties met, they tried to agree. There is a signed agreement or a two-sentence agreement that the parties signed. I guess the issue is whether the court believes that's a enforceable order. We would say it's not. There's no specificity there. When does it start? When does it stop? What holiday time, summer parenting time? It's just a simple agreement. My client tried that agreement for about a month, and he wasn't satisfied. Didn't think it was in the minor child's best interest, and then tried to re-engage Miss Cain to go to mediation. She declined, and here we are. So clearly, I think that the issue before the court is whether or not that 7 to 8 months significant change amounts to a change of circumstance. And then secondly, is that signed two-sentence, is that an enforceable court order that would stop Mr. Lucas from coming in to have a set and specific parenting time schedule, which he's allowed under the statutes of Michigan to be entered and be enforceable by this court. Just want to go back to some of the minor factual issues here. The response kind of paints Mr. Lucas out to be, some ne'er-do-well, bad fella. But, for that 7 to 8 month period when Miss Cain's housing was in question, wasn't secure, Mr. Lucas was there to step up, and there was no disagreement of the parties. So apparently during that time, Mr. Lucas was a viable candidate to care for the child, get the child to and from daycare and preschool. The allegation that, Mr. Lucas wants some specificity, wants some terms. He's concerned about, Ms. Cain made a statement about maybe moving to Lansing. So he's looking forward into the future. He's not trying to pry into her personal life or inundate her with communication. He wants a schedule that's going to work and that they can work around. And then I guess there was an allegation that Ms. Cain talked to Mr. Lucas about locking the bedroom door with his girlfriend. I mean, my client just simply states that communication never happened. They never talked about that. But even if it did, I mean, that would be significantly prying into somebody's personal life. So I know there are some communication issues between these parties. The response suggests the parties use Our Family Wizard. I talked to my client about that. He has no objection to using Our Family Wizard. So just in summary, this is clearly a change of circumstance or proper cause. There's some factual issues. I think this would be proper to send in front of the court for an investigation recommendation for custody and parenting time. Thank you.
Thank you. Before I turn to Ms. Retamaker, if I understand this, Mr. Arnson, Ms. Cain was going through, I don't know, call it what you will, some minor housing instability for about 6 to 7 months. Is that your understanding?
I would say 7 to 8, but yes.
Has that resolved itself now?
Yeah, to our understanding, Ms. Cain moved back in with her mother in, I think it was mid-September, and that kind of resolved the housing issue.
Okay. The trouble I have, at least with the custody request, is that there's a whole line of cases, and I know you're aware of them. I know Ms. Retamaker's aware of them too. Thoreau versus Dorr, 137, Michigan Appeal, 147. That's a 1984 case. Spears versus Spears, 108, Michigan Appeal, 543. That's a 1981 case. Straub versus Straub, 209, Michigan Appeal, 77. That's a 1995 case. All those cases stand for the proposition that when one parent, usually the custodial parent, is having some difficulties and they're temporary in nature, that when the other parent steps up, as Mr. Lucas commendably did in this case, that those line of cases suggest to me that once that issue has been resolved, which it has, that the custody would revert back, and that would not provide a basis for proper cause or change of circumstance. How do I get around those line of cases?
Well, I think those are a good point. You raise a good point, Your Honor. I think, when I look at those cases, I think Stoudemire is a newer one that's very similar to that vein as well. I think we're looking at two different things. Like, one, what was the nature of the instability or the issue why the other parent needed to step up? In our motion, we mentioned that Mr. Lucas assisted Ms. Cain in obtaining housing. Now maybe it wasn't ideal housing to have the minor child there for a significant period of time, but he did assist her with some financial means and other assistance as well. Additionally, so I think when you have an issue where there's some instability or something happens, there's usually some sort of, if there was a deadline on it, well, 2 months I'll be able to get back on my feet. 3 months I'll be able to get back on my feet. If there's some sort of timeline to that issue that would alter a significant or cause the significant change, I think that would be looking at, well, when the issue is resolved because there's a timeline, we revert back. Here there was no timeline. It was we had alleged upon information and belief to my client that there was some issue with Miss Cain's money being taken out of an account, stolen perhaps, and then she had moved out of the house. The other fact here, I think, is the time. When there is an instability or some change due to like an emergency or something, the longer that occurs, I think, especially if it's an over appreciable period of time, the I think it goes more towards a change of custody rather than reverting back. If a party went to jail for 2 years and got out of jail and said, well, that was a pretty big issue. Obviously I was in jail. I couldn't care for the child, and then comes out of jail, when wants to revert back to the original custody order, that 2 years, I think everyone would agree that was, that was not what that line of cases was meant for.
What about 1 year? What about 1 year while mom goes to school?
Again, and I think that would go to my first point where there's there's a timeline saying, hey, I'm going to school, there's going to be, for this year, we could do this, and then when I get out, so there's a timeline. So in this case, we have no timeline, it just happened. And then we have a 7-8 month window where this occurred, so.
The last question I have is, did you, or has that 2-sentence agreement been attached to your motion? Because I don't see it.
We did not, I don't know if my client had it handy when he filed the motion with my office. We referenced that the parties came to an agreement. Ms. Retamaker attached it to Ms. Cain's response.
Okay, that's the one you're talking about then, right?
Correct, yeah. And that was, I think that was, the parties signed that in October of 2024.
Okay. Thank you. Ms. Retamaker.
Thank you, Your Honor. Your Honor, I would argue, and some of your questions allude to this argument as well in regard to the proper cause or change of circumstances according to the VanDyke threshold in regard to the custody matter. It is true that my client, at the time of that February date, the house changed. She had a sister who divorced and she had to move in temporarily. Those circumstances changed. So she's like, I just need to not be here for a while. So the bottom line is, and this is why my client keeps such boundaries with the plaintiff in this matter, is it turns into drama. And so she keeps things very straight with him. And he's opportunistic with that, ergo this motion, in my opinion. There's boundaries for reasons. We are not trying to sling mud on the wall, but I had to give the court a little bit of a background and refer to the history in this case to show why boundaries have been set. And another example is this whole Lansing thing. I mean, it's just not a reality. We don't need to be concerned with it. My client interprets that as a prying. So what we have here is a very temporary situation that did not affect the stability of the child at all. Clearly, the parties ultimately communicate and work things out. She absolutely disagrees that the plaintiff had the majority of time. In fact, he didn't like weekends at all because that interfered with his time. So the parties worked through that, and then they recognized we do need to get something in writing. Let's get something in writing. And so they met. They're doing everything two parents should do in order to keep the lines of communication open. And then they agreed to that October 24 parenting time, which addresses a schedule. And they've been actually exercising that, I think, even prior to my client resuming her household where she currently is at and has always been at with the minor child. So that's been ongoing. I'm not really sure why now something's happening other than perhaps the holidays are coming up. And we recognize that the law allows for a specific parenting time schedule. And so that's why I attached Exhibit 2, which is the holiday schedule. And they need to work on that, possibly some of the summertime stuff. So there is not a change of circumstances. We know that occasionally maybe parents are going to have to move out of their current thing. It could be a fire. Temporary things are going to happen, and for good or bad, it's normal life circumstances. This hasn't been a pattern. This isn't a consistent thing that's gone on, and there's been no allegations of how it may have affected this minor child. So it just doesn't meet that VanDyke threshold, in my opinion. Even the shade threshold, we aren't really dealing with the modification of parenting time. We're dealing with it's scheduling parenting time, a specific schedule. That's really all this is about. The parties have an agreement. They agreed to it. Usually those are the best agreements. And that's the agreement we should incorporate into court order. And if necessary, refer the matter to the front of the court for parenting time mediation in regard to the holiday and summer schedule. We agree we can use our family wizard. That can be a good next step for this case. And we would ask the court to rule accordingly. Thank you.
One of the things that Mr. Arnson has in his motion that somewhat troubled me a bit was that your client was not agreeable to mediation. Is there any truth to that?
Your Honor, as I understand it, the parties, and I attached the text as well, communicated, and she was suggesting, why can't we just work this out ourselves? And lo and behold, they did. So it's not that she may not have said, well, let's not go to mediation, but it's because we can work this out. Let's try it. And they were successful. So that's my understanding of how that whole mediation not happening occurred.
Thank you. Mr. Arnson, I'll give you the last word.
Thank you, Your Honor. Briefly, the history of the case was mentioned, but there were some original pleadings filed when this case started. Some allegations were made. The parties went to mediation and came to an agreement. There's never been any sort of look into these facts, so there's a lot of factual disputes. We don't need to get into those. The question of whether or not this agreement was an actual agreement, the fact that Ms. Cain had primary physical custody and Mr. Lucas's parenting time was as agreed. This meeting was, they were not on equal playing field. Mr. Lucas, felt like certainly had to agree to something. Otherwise, I think we alleged in our motion that he was under the understanding that she was going to revert back and give him no overnights, which would have prompted a filing anyway. So Mr. Lucas was not, satisfied with what he signed, and he certainly believes that he signed it. Maybe not under duress, but certainly with the understanding that if he didn't agree to something, he wasn't going to get anything. Thank you.
Thank you. These cases always really troubled me before the holidays because I would rather the parties be discussing what they're getting their child, who I will use initials MDK, for Christmas rather than sitting around here and fighting about things. But it is what it is. The last custody order was a consent judgment of custody, and that was, as Mr. Arnson correctly points out, April 21st of 2021. The defendant mother was awarded physical custody, and the parties were awarded joint legal custody. Ms. Retamaker correctly points out that this court is bound by what we always refer to shorthand as the VanDyke threshold. It's based on the case of VanDyke versus Grassmeyer, 259, Michigan Appeal 499, a 2004 case. The allegations relative to VanDyke are really, if I boil down the motions, and both the motion and response were very well written, and I really appreciate that. But if I boiled it all down, the threshold implications, for lack of a better word, stated in Mr. Arnson's motion are that the defendant had a dispute with her mother and moved out temporarily and is now moved back in. And two, the parties can agree on mediation or on parenting time, as well as mediation. I don't believe that does meet the threshold under VanDyke for a reopening of custody. But I do find that poor communication and lack of cooperation, which is what this clearly is in this case, between parents does constitute a change of circumstance to revisit parenting time, and the relevant best interest factor found as to that is MCL 722.23J as in John, because what it does is it diminishes each parent's ability to encourage a close and continuing parent and child relationship between the other parent and the minor children or child. That was set forth in an unpublished case, Bauman versus Hartman in 2015, which, as the attorneys know, is not binding on this court for stare decisis purposes, but is certainly persuasive in this regard. So I do believe that under the shade standard that proper cause or change of circumstances has been proven by a preponderance of the evidence relative to parenting time. So I will send the matter to the friend of the court for a parenting time investigation and recommendation. Fees for that will be split between the parties. I will order that the parties enroll in and utilize our family wizard for all communications regarding this child that are non-emergent. Obviously, if there's an emergency, the parties have to have a line of communication, because otherwise most people don't check that. The last question I have, Mr. Arnson, and I'll ask you too, Ms. Retamaker. I am happy to send this to mediation before I enter that order. Only, however, if it will prove to be fruitful. If it's not going to prove to be fruitful, then we might as well just cut bait, I guess, and get to the front of the court. So, Mr. Arnson, your thoughts?
I believe my client would be on board with mediation. I know mediation went well the first time. I think that's why we had it in the judgment of custody. The parties would go back to mediation. I think any discussion needs to kind of be on an equal playing field. So I think at mediation with a unbiased mediator that would happen. So we would agree with that.
Thank you. Ms. Retamaker.
We agree.
All right, then before I do the order, I'll send it to mediation. The parties, through their attorneys, can agree on a mediator. If they can't, then the parties are free to contact the county's dispute resolution clerk, and they will give you the next person up in the queue, and that will be the mediator. The fees will be split evenly, and then if either party, either you, Mr. Arnson, or you, Ms. Retamaker, send my clerk an email saying mediation wasn't successful, then we will push the order of reference through to the front of the court. You don't have to come back. I don't want to burden this thing any more than it is. Mr. Arnson, I'll have you prepare the order to that effect. Any questions on what I need that order to say?
No, Your Honor, and I'll certainly send it over to Attorney Retamaker for review before sending that in.
Very good. Ms. Retamaker, any questions for me?
I do. Does front of the court have mediation services?
They do. It's up to you both. If you want to do that, I can make that referral today too. I don't know if that's a lot of times parties don't want to use their services if they're going to do a recommendation, but it's up to you.
I didn't know that they did do that, but I'll speak to Mr. Arnson about that, and I'm sure we'll figure one out.
Very good. Remember, and I think one of your attorneys hit the nail right on the head. Agreements between both of you last longer, are more fair, and result in less conflict. So I really hope that you both can work this out at a mediation, but if not, we're here for you. So thank you all very much. Happy holidays, and we're adjourned.
Thank you.
So I have, this is Mr. Noffsinger's objection to the friend of the court. And there's a couple of things that I want to say before I hear from the parties. First of all, you both are representing yourselves, okay? I understand that. The problem is you're making mistakes, and it's not even complicated yet. And pretty soon it's going to get highly complicated. So it's at this point in time that I'm going to reiterate to both of you that you both need to consider very strongly getting attorneys, because right now things are not procedurally that complicated, but they're going to be pretty quick here. This is an objection to the friend of the court, okay? When I told you back in August of this year, I told you two things. I said, first of all, we're going to send it to the friend of the court for a recommendation and investigation. And the second thing I told you was that you're not going to get everything you want, okay? And I don't know if you remembered that, Mr. Noffsinger, because you've now had an independent third party who doesn't know either one of you make a recommendation and you still don't like it. And generally, I understand that. But what happens when you don't like the recommendation, a lot of people think it's going to change dramatically, and it might, I don't know. But what happens now is the friend of the court completed their recommendation and filed it with the court, along with proposed orders and a 21-day objection period on 12/3 of 24. You barely waited a week before you filed your objection, Mr. Noffsinger, which troubles me. But it is timely. What happens from here is really up to the parties at this point. The second, or another issue I want to bring up deals with you, Ms. Goodrich. First of all, you can respond to a motion. I have no problem with that, and the court rules allow it. But that doesn't mean sending in 21 pages of text messages. Text messages don't work for me, okay? That's not how a response is supposed to be. And if you had an attorney, they would tell you you can't just send in 21 text messages, pages of text messages, and write something in the margin on each of them. That's not an acceptable answer. Then I get something today, a letter that apparently somebody wrote on your behalf. That's not acceptable, getting it one day before the hearing. I don't know when they sent it in. I can tell you, they sent that in. And the reason I point this out is this. They sent that, it's dated 12/18, okay? So I don't know when they sent it in, but it's dated 2 days ago. Court rules say all responses have to be in by Wednesday. I clearly didn't get it. Now, I'm not pointing this out to you since I didn't read it. I read everything, both of you. But you're both making mistakes here, and we're not even to the complicated part yet, okay? So there's two avenues we can go. Number one, if the parties think that they can work out some sort of agreement with the help of a mediator, then I'll send it over there. I'll send it to mediation. If the parties don't think they can get together and come up with an agreement, then we're going to schedule it for trial. And then it's going to get very complicated. So I'll ask you, Mr. Noffsinger, do you think you can resolve this at mediation, or do you think we should just go ahead and schedule it for trial?
I want to say mediation, but it's extremely a very hostile environment between her and I want to avoid trial. Like I said, it's a tale of lesser two evils here. Because the only reason I filed the objection was because I had recommendation from our CPS caseworker to do so.
Yeah, I agree. I get it. Your objection is there. It's timely. And CPS doesn't work for me. So, I understand they are influential and they may work for, the state and they're influential to you. But, why is it so hostile, Ms. Goodrich?
In regards to the fact over the summer, for the past 5 years, I've been with my kids every day. And then after going and Henry taking away the children and keeping them from me, it is a very triggering aspect for my trauma disorder.
I don't know what that is.
And I have PTSD.
Right? Well, but see, here's the problem. And if you,
And I'm working on it.
I know you are, and I appreciate that, and I commend you for doing that. Not something I want to throw out there for public consumption, though, because I don't want you to say something that would give me pause, because you two, you know, unfortunately, you're not together anymore, but you're parents. And by the very fact that you're parents, you have to be able to work together. This child didn't ask for this. So I think what I'm going to do is this. Is there any type of PPO or anything out between you two?
Nope.
No.
Okay. Then what I'm going to do is, you both got pens? You can write this down.
Yes.
I'm going to order mediation pursuant to Michigan Court Rule 3.216 at the Dispute Resolution Center of West Michigan. They're in the phone book. And what they will do, you call them up, both of you, and schedule a mediation. And they work on a sliding scale based on incomes. So that's a good thing. Other mediators cost $300-400 an hour. So we're going to try that first. You're to call them within the next 10 days, and they will schedule a mediation for you. And then if it's unsuccessful, okay, if it's not successful, then either one of you can call or email my clerk, tell her it wasn't successful, and then we're going to schedule an evidentiary hearing for you, or a trial as we call it. Let's start there. So we'll hopefully can get this resolved. If it doesn't, then we're going to have a trial on it. I don't have any other option. I only got
Okay.
Okay. Those are the only two options.
Is there a way that I can inquire that Henry respond on the Our Family Wizard app and not Kathleen, as they are separated?
I don't know who Kathleen is.
That's his wife.
Is there an
And
order?
he gave her access to the app.
Okay, so there's an order for you both using Our Family Wizard?
There isn't. I bought it and paid it. He got it waived. And we were recommended by a police officer over the summer to use it and inquire about it. I just took a proactiveness and acquired it, and then implemented and asked for it to be implemented by Henry, which he obliged.
Okay, then I will order Our Family Wizard, and I'll order it between the parents only. But you know, that's only a Band-Aid, you two, because once if it's an emergency, you can't use Our Family Wizard because you got to have immediate response. So you both are going to have to learn to deal with one another. Both seem like good people. I can't think of any more reason to start getting along than your child. If not for that child, who then? Who's more important to you in this world? Nobody. better not be anybody. Your child is. So you owe it to them to get this together. Start using our family wizard, both parents, call the dispute resolution center, get things written down, and start following them. If not, then we'll have a trial on this. But I'll warn you both, it's going to get very complicated. Trials are not easy. Attorneys mess them up too.
I do have another inquiry.
I
His
don't
wife
have a
had
whole lot-
stated, I
Okay.
understand that, but I feel as though it is very pertinent. His wife, Kathleen, had stated that she was going to file for guardianship of AN. In the instance that she gets granted a guardianship and she follows through with that, how does that reflect this situation?
That's a perfect question to ask your attorney. I don't get into those situations. Obviously, if she did that, you would have your say in probate court for that. I can't give you legal advice as to that kind of stuff. But this is why it's going to get complicated. I don't know why a probate judge would even entertain such a thing, but what there doesn't seem to me, if you have two parents that have a child, I don't know what the need for a guardianship would be, but somebody can explain that at a later date. All right, you're all set. Have a great holiday, and hopefully you guys can work it out. If you can't, then I'll work it out for you. All right.
Thank you.
Thank you.
Mr. Mays is not here. I'm looking at your motion, and it says, in fact, the renotice of the motion says that on November 22nd, you sent Mr. Mays a copy of this motion for custody at his address on Seward. Is that correct?
Yes.
And he is not here, obviously, and it's 9:47 according to my courtroom clock. Have you spoken with him? Has he reached out to you?
He knows about the court date and everything. So
Okay.
I'm not sure what's going on.
Okay, and he's not
So,
here today.
yeah.
Okay. So this was adjourned from November 22nd of 24 because I think of notice, wasn't it?
Mhm.
Yeah. The last custody order was the judgment of support dated May 17 of 2024. The plaintiff mother, Ms. Solano, was granted the initial custody, both legal and physical.
Okay.
As far as legal custody, mother, you have it, subject
Okay.
to a judicial determination as to that issue. In essence, you have full custody, legal and physical. If he were to file a motion for legal custody, I would have to hear that, but he hasn't done that. And until he does that, you have the custody of, and I'll use their initials, GKM and JSM, both one's 4, one's 5. It looks like the problem might be, I can't give you custody because you already have it.
Right.
So does the issue appear to be parenting time?
Yes. I think hold on, my video went out. Yeah.
No, there you go.
It's parenting time that I'm really asking for.
Okay.
And to use the I think it's called the Wizard app.
Our family wizard?
Yeah.
Okay. Do you have a pen with you?
Yes.
Okay. So I'm going to grant your motion to take a look at parenting time.
Thank you.
And I'm going to send it to the friend of the court for an investigation and recommendation. But do you think you and Mr. Mays can sit down and come up with your own agreement?
We have a schedule that we've been working with. It's more of the communication. Like my communication is good with him. It's getting it back because when he doesn't get his way, it's aggressive.
Oh,
And I just don't want to be able to contact your phone unless it is an emergency.
okay, so you don't really, you guys got parenting time squared up, but you just need help communicating together.
Yes, basically.
Okay, then you can prepare an order and I'll order both parties within the next 10 days to subscribe to and obtain our family wizard. And then all communication about the children, except for emergencies, will be
Okay.
by our family wizard. Okay?
Thank you. Thank you so
All
much.
right. Then you prepare that order. The Legal Assistance Center will show you how to do that. And they will get it to me. I'll sign it. And then the 10 days will start ticking. Okay?
Okay.
You have a great holiday. Okay?
Thank you so much.
You bet. You're all